Conflicting decisions of high courts on the powers of the Economic and Financial Crimes Commission to investigate the accounts of states are distracting the anti-graft agency from actualizing its mandate. 2 weeks ago, a federal high court sitting in Gusau, Zamfara, held that EFCC did not have the powers to investigate the accounts of Zamfara State. Before then, a federal high court sitting in Noka, Anambra State, had dismissed the suit filed by the Anambra State government challenging the commission's power to investigate its finances, describing it as factually and forensically lacking in merit. These judgments appeared to have ignored the 2002 decision of the Supreme Court in Attorney General of Ondo State and Attorney General of the Federation, where the highest court in the country stated, amongst others, that the EFCC Act, being a creation of the National Assembly, is binding on states, persons, and entities. Well, Arise News analyst Frank Tietie joins me now in the studio to dissect this knotty legal issue. These are the kind of legalese that, puts Nigerians at bay when courts of concurrent jurisdiction, or how do you call it in legal parlance, given, judgments that are parallel.
No.
Where there is a sitting Supreme Court.
Not quite. I think that's why you refer to it as being knotty, because it requires unraveling. So when you put a question before a court and you put certain facts, the court is restricted to the questions and the conflicts that you have brought. So the court will not go outside of it. So in one instance, if you approach the court and say, with regards to the powers of the State House of Assembly to investigate the funds that it has appropriated, the way any authority, persons, or ministry, department of an agency of the state government expended the money, of course the court will agree, because that is what Section 128 of the Constitution says. Section 125, in addition, says that states can actually, together with Section 120 specifically, states can actually, particularly State House of Assembly, can investigate that. But when you approach the court with a conflict, stating clearly whether the EFCC cannot investigate the finances of state, can or cannot investigate the finances of state, you no longer need any guesswork with regards to that. The Constitution of the Federal Republic of Nigeria, together with the decisions of the Supreme Court, support that, whether the Supreme Court decision in Dariye and Federal Republic of Nigeria, or Jolly Nyame and Federal Republic of Nigeria, and the matter before between the Attorney General of Federation and that of Ondo State. So it's clear. The Supreme Court is clear on that, and it amounts to self-deceit to think, and then tend to be very mischievous to think that you would misappropriate Nigeria's money because you are in Zamfara and because you are a governor, and you think the money, because the money was appropriated by the Zamfara State House of Assembly, the National Assembly of Nigeria cannot be interested in what you do, or an agency of the federal government like the ICPC or the EFCC is not interested in what you're doing. You must be in a dreamland to think that that is the situation of the law. The Supreme Court made it clear that Nigeria is a state. We forget. Nigeria is a state. And all the citizens of the various subunits of the various states, whether Zamfara, Delta, or Edo, all belong to a state called Nigeria. And Nigeria, the Nigerian National Assembly, particularly with regards to Section 4, subsection 5 of the Constitution of the Federal Republic of Nigeria, when the National Assembly makes a law on a subject matter, and the State House of Assembly, any State House of Assembly also makes a law on that subject matter, whenever those laws conflict or they clash, the law is clear, the Constitution is clear that the law of the federal government will prevail. So in this case, it's a matter of financial crime or corruption in general. It is, and a federal agency this time around exercising prosecutorial powers, can take interest in what happens in any state whatsoever. And anybody who steals money is not stealing the money belonging to Delta State or Zamfara State alone. He is stealing money belonging to the Nigerian people, to the Nigerian state. And any prosecutor for that matter, whether in the state or in the federal government, can take up that person. So that is a settled matter before the law. There is no doubt about that.
If you call it a settled matter before the law, the conflicting lower courts, judgment or adjudication on this matter will hamstring the EFCC.
Not at all. No, not at all.
Wouldn't they have to discharge?
Not at all.
The
not
order
at all.
of the courts?
No, see, we need to understand the principle of hierarchy of courts in our country, and that we don't just have a Supreme Court for nothing. Now, and I've explained to you at the outset of this conversation that it depends on the facts and the questions that are put before a court to determine. So, in those courts, and again, I don't want to shy away from the fact that people can approach friendly courts, especially state governors that have the power to appoint judges. They can approach those courts and get favorable judgments based on the fact that the facts that are presented to them and the questions that are given to them to determine are actually restricted, and the court itself is restricted. But you ask a direct question: can the EFCC investigate the matters that have to do with financial crime or corruption, all forms of crime in that matter, with regards to property, monies belonging to the Nigerian people, whether they are from Zamfara or from Delta or from Edo? The question is settled by the Supreme Court, yes. And that's the reason why the EFCC does not need to bother itself in interpreting, constraining itself into its choosing or picking and choosing. No, it doesn't have that option. The provision is this, and I refer to Section 4. When the National Assembly of Nigeria made a law with regards to fighting corruption, fighting financial crimes, especially, in fact, if you look at the provision of Section 6 of the EFCC Act, it talks about all crimes, all financial crimes, all forms of corruption, with regards happening anywhere. In fact, if you need to understand that crime has even gone beyond national borders, that the international community is even interested in what you do with the resources of subunit states like Zamfara or Delta. I can tell you that because the whole idea of the United Nations Convention Against Corruption is that you can see how the world appears to be, appears to be united against money laundering. So whatever you think you're doing at a local level, you are saying that it is not a matter of anybody's interest because you think it's the money that belongs to your people. You must be joking. In Nigeria today, whatever you do, whatever form of crime you commit, the federal government or the state government anywhere can take interest in that, so long as the person is exercising the prosecutorial authority of the Nigerian state. That's very important. And again, you need to know that it doesn't matter whether, you see, the expectation is that the state government, the state National Assembly, the State House of Assembly ought to actually, by Section 120 of the Constitution, by which this judgment has emanated from Zamfara State High Court, can actually investigate. But we know the psychology, we know the circumstances that will not make them do any proper investigation. And in that case, just like the complementarity principle of the international criminal law, the federal government looking at a State House of Assembly or looking at the prosecutors in the state, turning a blind eye to a crime, to a financial crime, or to a blatant, brazen corruption by any public official, the federal government, the institutions of the federal government, particularly the FCC, can and must take interest in that. And it should not in any way submit to any form of intimidation or judgments that are influenced by persons that are friendly with those that appointed them. It is normal. That's why there are individuals.
I'm happy you're not saying procured judgments. No. Friendly courts they can approach.
The expectation is this: a judge is a human being.
Oh yeah.
The judge has proclivities. The judge addresses his mind based on certain influences and factors that are peculiar to him. In this case, he's a state judge appointed by this governor, and you are saying, and the governor approaches him for a particular application for a particular motion or order. These things are done normally, and the judge most likely,
whether there is
despite
the merits of the merits.
No, the judge is most likely to be influenced by his persuasion because of the factors surrounding the case that he's sitting on. And that's the reason why judges must, at certain circumstances, recuse themselves. But they mustn't, because of certain interests they know they have.
Yeah.
Ideally, if the governor was smart, he ought to have approached the Federal High Court.
Absolutely.
And in that case, we will have a more neutral judgment.
All right. Frank Tietie, lawyer and a rights analyst, thanks for dissecting that for us. All right.